Cortney Marie Bartholomew.
This is the case of the people of the state of Michigan versus Cortney Marie Bartholomew, case number 254994FY. We're here for an arraignment. Ms. Bartholomew, did you have the opportunity to meet with somebody from the defender's office either yesterday or today?
I did.
I have a complaint that alleges that on or about November 3rd, 2025, in Antioch Township and or Boone Township of Wexford County, it is alleged in count number 1 that you committed the offense of homicide, murder in the first degree, premeditated upon Rebecca Park. That is a felony punishable by up to life without parole and DNA to be taken upon arrest. In count number 2, it is alleged that you committed the offense of homicide, felony murder upon Rebecca Park. That is a felony punishable by up to life without parole and DNA to be taken upon arrest. In count number 3, it is alleged that you committed the offense of torture. That is a felony punishable by up to life or any term of years, and consecutive sentencing may be imposed if it happened in the place of confinement. In count number 4, it is alleged that you committed the offense of conspiracy to commit torture with Bradley Bartholomew. That is a felony punishable by up to life and or any term of years and or $10,000. And again, consecutive sentencing may be imposed if it happened in the place of confinement. In count number 5, it is alleged that you committed the offense of assault, pregnant individual, intentionally causing miscarriage or stillbirth. That is a felony punishable by life and or any term of years. In count number 6, it is alleged that you committed the offense of conspiracy to commit assault, pregnant individual, intentionally causing miscarriage, stillbirth. That is a felony punishable by life or any term of years. In count number 7, it is alleged that you committed the offense of unlawful imprisonment. That is a felony punishable by up to 15 years in prison and or a fine of $20,000. In count number 8, it is alleged that you committed the offense of dead bodies removing them without medical examiner permission. That is a misdemeanor punishable by up to 1 year in jail and or a fine of $500. Do you understand those charges and the potential penalties?
Yes, Your Honor.
On felony complaints, you have certain rights. You have the right to remain silent. Anything you say or write can and will be used against you. You also have the right to be represented by an attorney during any questioning that you consent to and the right to stop answering questions at any time. You also have the right to be represented by an attorney, and if you could not afford one would be appointed to represent you at public expense, but you may be required to repay a portion of that expense. Do you understand that?
Yes, Your Honor.
Today, do you plan to hire an attorney, represent yourself, or request the appointment of an attorney?
Request.
The court will make a referral to the public defender's office for the appointment of an attorney. You will enter a not guilty plea on your behalf and will set the matter for a preliminary examination. That's a hearing that's held here in the district court within 21 days. At that hearing, the prosecution will be required to prove 2 things. 1, probable cause that these crimes had occurred, and 2, probable cause that you were the person who committed the offenses. If the prosecution is not able to do that, the case would be dismissed. But if they are able to do that, you'd be ordered to stand trial in circuit court. Prior to the preliminary examination, there will be a probable cause conference. That's where your attorney and the prosecutor will get together to see if there was a way to resolve the case short of going to trial. Do you understand that?
Yes, Your Honor.
You also have the right to have a bond set. Your bond is based upon the probability of you appearing at future court appointments, the seriousness of the offense charged, and the threat that you pose to the public. Counsel, the praxis scores her at a risk level 2. In the defendant's past, I show in 15 the driving the license suspended second, 18 driving the license suspended, 19 allowing another person to operate in violation of the motor vehicle code, and 20 lying to a peace officer in a 1 to 4 year investigation, actually 2 convictions for that. In 05, a driving the license suspended that was set aside. In 05, a financial transaction device fraud withdrawal 200 to 1,000 that was set aside. In 14, there was a driving license suspended set aside. In 18, false or forged ID set aside. On the local record not shown in the CCH, there was an 03 stray dog and an unlicensed dog, 04 unlawful plate, 05 attempt failed to report an accident, and 15 drive without a license, drive with a license expired, and 17 allowing an unlicensed driver to operate, 19 allowing an unlicensed driver to operate, and in 23 false report of a misdemeanor. Mr. Martel?
Yes, Your Honor. We do realize these are very serious allegations. And she does, as the court did note, have a prior criminal history, nothing anywhere relatable to this. I would ask the court to factor that in when setting bond. I have had contacts with her in the past. I did represent family members of hers. I won't go into too much detail about that, but what I will say is, without giving the address on record, I am familiar that she does have strong ties to that area. She does have friends and family and support structure in the area. She also has a variety of disabilities that I won't go into too much detail just for respect of her, but she does have upcoming medical appointments, MRIs, CAT scans, things of that nature, just so the court is aware. I don't believe she's a flight risk, not only due to the fact of her ties to the community, but also due to her need to do those medical appointments. I do believe that she would obey any non-monetary bond conditions the court placed on her if the court had concern for public safety, which we don't doubt would be appropriate in this scenario. No contact with alleged co-conspirators, house arrest, things of that nature. I do realize the court's not required to set a monetary bond, but I would ask the court to consider it, including factoring in her disability, her low income, and the fact that her prior criminal history doesn't have these type of allegations in it. Thank you.
Ms. Carey.
Thank you. Again, the people are going to request the court deny bond in this case pursuant to MCR 6.106B1, which allows the court to deny pretrial release to a defendant charged with murder. She is charged with murder. She's also charged with felony murder and 6 other counts, as the court read. I hate to repeat it, but to create a record in this case as well, I think no bond or being held without bond is appropriate. Again, this is a case of premeditated torture and murder. These two individuals created a plan, conducted research. Ms. Bartholomew brought Rebecca to their home. They forced her into another vehicle and took her into the woods, where they stabbed her, forced her to lie on the ground while they cut her baby out, and ultimately caused her death and the death of the baby. They then left Rebecca in the woods. This is, frankly, evil personified, and I would ask the court to hold her without bond.
The court does find, based on what's been presented to it today, the probable cause affidavit I've read and various search warrants I've read, the defendant is both a flight risk and a threat to the community, therefore she will be held without bond. I am going to order...
Your Honor, I have a
No. I'm also going to order that the defendant not having contact with Bradley Bartholomew, and I'm going to sua sponte go back and add that requirement to his bond conditions as well. Counsel, anything for the record?
No, sir, thank you.
No, Your Honor. Thank you.
All right, thank you, Wexford. I will hold off on calling the next cases to allow the courtroom to